Recording in progress.
Good
Good
morning,
morning, good afternoon, and good evening to all of you joining us from across the globe. Ladies and gentlemen, esteemed guests, distinguished speakers, and respected participants. It is both an honor and privilege to welcome you to this important and timely international webinar on the intricate interplay of investment law and intellectual property. As we gather virtually today, we stand at the crossroads of two powerful and increasingly interconnected fields: investment law and intellectual property rights. This intersection raises significant legal, economic, and social challenges, particularly as we examine how international investment law interacts with the domestic legal frameworks, and how the concepts such as property and rights are interpreted across the different jurisdictions. As the coordinator of this event, I stand before you today not just as an organizer, but as a firm believer of importance that fostering dialogue on the evolving and often complex relationship between investment law and intellectual property. In the global investment arena, it becomes increasingly clear that the intersection between domestic legal system and international treaties and investors' protection presents both challenges and opportunities. These intersections, especially in the context of intellectual property, calls for a nuanced approach to understand how national regulations interact with the international law. Today's webinar offers a unique platform to critically engage with the key questions. What is the role of international investment tribunals in adjudicating disputes related to IPR, and what are the implications for the state sovereignty and investors' rights? This question lies at the heart of several landmark cases as we speak directly to the broader themes of the regulatory autonomy and the sovereign states for the enforcement of intellectual property and global investment integrity. Why is this? This discussion such paramount and importance, particularly in the context of India. The Indian legal framework has long been recognized for balancing intellectual property laws with the broader economic, social, and cultural objective of the state. As a rapidly growing economy and global hub for both innovation and foreign investment, India stands at the crossroads of intersection. While we continue to encourage international investment, we must protect our national interest, including our intellectual property regime, which is integral to fostering innovation, creativity, and entrepreneurship. International Investment Tribunal, with their ability to rule on the matters of the expropriation, compensation, and treaty violation, have the power to influence how the domestic IP laws are interpreted on the global stage. Yet, as we will explore today's very nature of IPR that is deeply embedded in the national legal systems adds layers of the complexities when dispute arises over the granting, revocation, or limitation. One of the prominent examples of this complexity is the Philip Morris versus Uruguay case, where the tobacco giant challenged the Uruguay's tobacco regulation as violation of its trademark rights. The tribunal was forced to navigate tricky terrain between the IPR protection and public health law and public policy, while also determining its jurisdiction over issues traditionally governed by the national laws. These cases highlight the importance of ensuring that investment law respects the regulatory autonomy of sovereign states, especially in the matter as sensitive such as public health and intellectual property. As we move through today's session, we will engage with the range of topics and questions that critically examine the relationship between these two, intellectual property and investment law. What are the boundaries of international tribunals' jurisdiction over the matters involving IPR, especially when they resolve and involve the national regulatory decisions? How do the arbitral tribunals balance domestic courts' decision with their own interpretation of investment treaties, and particularly when it comes to the IPR cases? How does investor-state dispute settlement mechanism interact with intellectual property law? What are the implications and compliance enforcement for the global standards, and particularly in Indian scenario? How have investment tribunals interpreted and applied IP laws in their ruling, and what the role of the national laws that shaping interpretation? How can we safeguard the interest of investors while ensuring that the states retain control over the regulatory policy, especially in relation to health and environment and public welfare? Intellectual property is not a one-size-fits-all legal framework. How do the cultural and national context influence IP regulation, and how does this impact global investment disputes? What lessons we can learn from these cases like Philip Morris versus Uruguay or Eli Lilly versus Canada and others have shaped the intersection between IPR and investment law. By acknowledging these complexities of these two fields, we can help and shape our future with the both to protect investors' rights and respect the state's sovereignty, and where the national legal systems and international treaties work in harmony to promote global investment and integrity. Without further ado, let's take let, let's take you to the today's exciting program. And the first session, we have our Honorable Vice Chancellor here. Our first session will features by inaugural address by our esteemed chief guest, who is our Vice Chancellor at Mysore University, Professor Dr. Lokanath. He will take the stage at 2. It's 2:05 to deliver inaugural address, setting the tune for the discussions for today. Following that, we will have our guest of honor, Professor Dr. Prabhash Ranjan, Professor and Vice Dean at General Global School, Professor and Vice Dean at Global University, India, who will present on India's perspective and complexities of IPR and investment. This will provide us with the valuable insights to India's evolving approach and intellectual property and investment. Following that, in the second session, we're moving to hear from Professor Srinivaslu, Professor of Law at National Law University, Juridical Sciences, Kolkata. We'll kick off the session with the keynote that is titled Interplay of IPR and Investment Law in India's Evolving Space Industries. Next, we have Professor Antonio Jorge, Pereira Junior, Professor at Unifar University of Brazil. He will discuss protecting IPR and investment within the BRICS and several highlights on the challenges and opportunities between India, Brazil, South Africa. And finally, we have Dr. Kenneth Mutama, who is a senior faculty at Nairobi Law School, Nairobi, Kenya. And the third session, we have a special talk, which is supposed to be right now due to the time variation and flight of a scholar. It is going to be by 6:30 p.m. in Indian time and 2 p.m. at Madrid. And we are honored to close our webinar with Professor Dr. Nicolas de Sadeleer, Professor of Upilian, Brussels, Belgium. His title talk would be Europe Paradigm, Europe IPR as an investment and the vision for the multilateral investment code in Europe 2025. And we are looking forward to an engaging discussion and learning from our distinguished speakers. Before we begin, I would like to thank all of our esteemed guests, speakers and participants for making this event possible. Now, let's officially start and begin with the welcome address by Professor M.S. Benjamin, the President of the program and the Chairman, Department of Studies in Law. Sir, over to you.
Thank you. Good afternoon, Honorable Vice Chancellor, distinguished speakers, esteemed participants, panelists, and dear colleagues. As a Dean Faculty of Law and a Chairman of Department of Law, University of Mysore, it's my pleasure to welcome you all to this international webinar on the intricate interplay of investment law and intellectual property in India. As you know, in 1991, India implemented a new economic policy by signing the WTO agreements. It was a very significant phase in the history of India's economy. It replaced a closed and controlled economy with an open and liberalized one. As a result, India reformed its domestic laws. For example, the Monopolies and Restrictive Trade Practices Act of 1969 was replaced by the Competition Act of 2002, the Foreign Exchange Regulation Act of 1973 was replaced by the Foreign Exchange Management Act 1999 and amended IPR laws in tune with the TRIPS agreements of WTO. In recent years, India is one of the leading economies in the world to attract foreign investment in IPR, that is innovation, research and development, advancement for technology and creativity. Investment, that is foreign direct investment in IPR, promotes economic growth, efficiency, competitiveness, and global integration. This webinar provides a platform to debate and discuss the interrelationship between the investment law and IPR laws. We are honored to have with us Professor N.K. Lokanath sir, Honorable Vice Chancellor, University of Mysore, Mysuru, Karnataka, South India, as our chief guest for this inaugural session. Sir, on behalf of the Department of Law, University of Mysore, I heartily welcome you to this international webinar.
Thank you.
We have Professor Prabhash Ranjan, Vice Dean, Jindal Global Law School, OP Jindal Global University, Haryana, as a guest of honor. On behalf of the Department of Law, University of Mysore, Karnataka, I welcome you to this webinar. I also extend a warm welcome to Dr. N.S. Srinivasulu, Professor, National University of Jindal, National University of Juridical Sciences, Kolkata, West Bengal. To Professor Antonio George, Unifor University, Brazil. To Professor Kenneth Wine Mutuma, Senior Faculty of Law, Nairobi Law School, Nairobi University, Kenya. To Dr. Nicolas de Sadeleer, Professor and Chair of European Union Law at St. Louis University, Brussels, Belgium.
Yes.
I also extend a warm welcome to all panelists, paper presenters, participants, to my esteemed colleague, Professor Ramesh, the organizing secretary, and my research scholar, the Kudrat Hasmi, the secretary for this program, coordinator, and Ms. Sarah. I once again welcome you all to this webinar. Thank you all.
Thank you, sir. First, it is my privilege to call upon our chief guest. Before we start with our Honorable Vice Chancellor, I would like to request my colleague to brief out about our Honorable Vice Chancellor. Please.
It is my great honor and privilege to introduce a distinguished academic and scientist whose career exemplifies excellence in research, education, and leadership. Professor Dr. Lokanath N.K. academic journey spans continents and groundbreaking achievements. He has held prestigious positions, including serving as a scientist at Riken Spring Center in Japan, a postdoctoral fellow at Samsung Biomedical Research Institute in South Korea, and a research associate at the University of Mysore, Karnataka, India, where he also completed his PhD in physics. Currently, Professor Dr. Lokanath N.K. serves as a professor in the Department of Studies in Physics at the University of Mysore. His dedication to academic advancement is evident through his leadership roles as the nodal officer for initiatives such as the National Education Policy 2020 and the Cosmos Project. He is also the driving force behind several significant programs, including the Fund for Improvement of Science and Technology Infrastructure of Department of Science and Technology, Government of India Initiative, and the National Single Crystal Diffractometer Facility. Professor Dr. Lokanath N.K.'s contribution extends beyond academia into the realm of administration and mentorship. He has held pivotal roles such as the Director of the Planning, Monitoring and Evaluation Board and College Development Council, and the Chairman of the Department of Studies in Physics. His research has often been featured in prestigious publications and also been recognized with honors such as the Sir C.V. Raman Young Scientist State Award, which showcases his profound impact on advancing physics. Professor Dr. Lokanath N.K. is also an inventor with two patents filed in 2022 focusing on the nano-microstructures for carbon dioxide reduction selectivity and engineering serum oxide nanoparticles for superior photocatalytic activity. His contributions to academia and industry are complemented by his engaging role as a speaker, having delivered over 85 invited plenary and technical lectures at esteemed institutions worldwide. Now over to you, sir.
Greetings from the Mysore University, because it's a webinar around the globe. So good morning, good afternoon, good evening. So I don't know where you are all, depending on where you are. Distinguished speakers and my colleagues, Dr. Ramesh, Professor Benjamin, esteemed participants and fellow scholars joining us from across the globe. It's both honor and privilege to welcome to this highly significant international webinar on the intricate interplay of investment law and intellectual property in India. I'm really happy that this is one of the very important and timely discussion. Today, we are here to explore two critical domains of law that are shaping the future of our global economy: investment law and intellectual property law. Of course, this is a subject of utmost importance, particularly in the context of India's emergence as a key player in the global marketplace, as well as rapid evolution of knowledge economy. Investment law and intellectual property law are both functional pillars in today's globalized legal and economic systems. While investment law traditionally focuses on promoting foreign and domestic investments and protecting capital flows across borders, intellectual property rights have increasingly become central to the competitive dynamics of innovations-driven industries. As we all aware of that, India is now emerging as a dynamic economy. There's been significant growth in sectors such as technology, pharmaceuticals, biotechnology, and entertainment. In this context, intellectual property rights have gained unprecedented significance in attracting foreign direct investment, fostering innovation, and protecting valuable knowledge-based assets. However, the relationship between investment law and intellectual property is multifaceted and complex. So it is not without challenges, particularly in balancing national interests with global legal commitments and safeguarding the rights of investors while ensuring the public interest. At this juncture, the intersection of investment law and intellectual property has become more critical than ever, as these two domains increasingly overlap in areas such as technology, transfer, data protection, and protection of IP-intensive sectors. The challenges are particularly apparent when we consider the role of international investment treaties, such as bilateral investment treaties and free trade agreements, which often include provisions for the protection of intellectual property rights. India's journey in strengthening the intellectual property laws and policies, especially in alignment with the TRIPS agreement, has been remarkable. Over the years, as we have witnessed a significant increase in IP filings, improvements in enforcement mechanisms, and the development of robust IP frameworks. These advancements in India have played a critical role in attracting foreign investments to key sectors such as technology, pharmaceuticals, and biotechnology. However, the progress also brings with it a host of challenges. One of the most pressing issues is the balancing act between protection of IP rights and ensuring access to essential goods such as life-saving medicines and technologies. This becomes particularly critical in sectors like public health, where the tension between protecting patent rights and ensuring affordable access to medicines can sometimes lead to contentious legal and policy debates. Moreover, the rapidly evolving nature of global commerce, driven by emerging technologies such as artificial intelligence, blockchain, and biotechnology, has introduced new complexities leading to new challenges. Issues like data privacy, cyber security, and the protection of trade secrets are just few of the novel challenges that are reshaping both investment law and intellectual property law in India and as well as around the world. It is in this context today this webinar is particularly valuable. We have brought together experts from various domains: law, economics, technology, and policy making to engage in a multidisciplinary dialogue. The goal is to unpack the intricate relationship between investment law and intellectual property and to identify both the challenges and the opportunities that arise from this intersection. Our distinguished panel of speakers today will discuss critical themes such as the role of national IP frameworks in attracting foreign investments, the intersection of investment treaties and IP law, and the evolving role of international arbitration in resolving investment disputes related to intellectual property. I am very much confident that their insights will provide a wealth of knowledge, highlighting the multifaceted dimensions of this crucial issue and offering practical solutions for the future. India's position as a hub of innovation investment provides a unique opportunity to lead the way in striking this delicate balance. In order to achieve this, we must continue to engage in ongoing research, dialogue, and legal reform such that our laws are responsive to the evolving challenges and opportunities that arise in the interface between investment law and intellectual property. In conclusion, I would like to express my deepest gratitude to all the distinguished speakers, participants, and organizers who have come together to make this event possible. I am also confident that today's discussion will contribute immensely to advancing our understanding of the dynamic interplay between investment law and intellectual property, not just in India, but across the globe. I encourage each of you to approach today's sessions with an open mind, a collaborative spirit, and a commitment to advancing both justice and development. The future of investment and innovation depends on our ability to build a legal framework that is not only fair and transparent, but also adaptable to the rapid changes we are witnessing in the global economy. Let's all engage with passion, purpose, and a shared commitment to finding innovative solutions to the complex legal challenges before us. I now look forward to the insightful presentations and discussion that lie ahead. I am confident that this webinar will be a thought-provoking and enriching experience for all of us. And finally, I thank all the organizations, secretaries, organization members. Thank you for giving me an opportunity to speak few words on these occasions. Thank you, and I wish you all a fruitful and engaging session. Thank you.
Thank you. Thank you, sir, for your enlightening address. Now, it is our privilege to invite our guest of honor. Before starting the virtual stage, I would like to request my colleagues to brief out about Professor Dr. Prabhash Ranjan, Professor of Law at Jindal Global University.
It is my distinct honor and privilege to introduce to you a luminary in the field of international law and trade, a scholar whose work has significantly influenced both academia and policy making. Professor Dr. Ranjan is a distinguished academic and a thought leader in international economic law, investment treaties, and their implications for developing countries. He serves as a professor and vice dean at the Jindal Global Law School. He holds a PhD in law from King's College London, where he studied on a King's College London doctoral scholarship. Sir is also a visiting professor at the National University of Jurisdictional Sciences, Kolkata, and an international fellow at the National Institute of Military Justice, Washington, D.C. Professor Dr. Ranjan's expertise has not only been acknowledged within academia, but also by governments and international organizations. He has been a key contributor to discussions on shaping policies around investment treaties and trade agreements, providing invaluable insights to ensure that these frameworks are equitable and inclusive. Professor Dr. Prabhash Ranjan was a member of the team that drafted the 260th report of the Law Commission of India on the 2015 Draft Model Indian Bilateral Investment Treaty. Sir has also deposed as an expert witness on India and bilateral investment treaties before the Parliamentary Committee on External Affairs. Sir teaches and publishes in international investment law and international trade law and has published close to 70 peer reviewed research papers in several leading international journals and edited books published by leading global publishers. Please join me in giving a warm welcome to a brilliant scholar and inspiring educator and a champion for equitable international law, Professor Dr. Prabhash Ranjan.
Thank you very much for that generous introduction, Professor Lokanath, Honorable Vice Chancellor of University of Mysore, Professor Benjamin, Professor Srinivasalu, my old friend and dear former colleague at NUJS, and all the distinguished guests and participants. It gives me immense pleasure and honor to be part of these discussions. And let me start by congratulating the Department of Law, University of Mysore, for organizing this webinar, bringing together two streams of or two branches of law which have evolved independently of each other. As legal scholars or as lawyers, we often tend to work in silos. So we have people working either in international investment law, or we have people working either in intellectual property rights. But this is a unique webinar which has brought both these subjects together and has forced us to break these silos and look at how they interact with each other. So please accept my felicitations on doing this. And thank you once again for inviting me and giving me this opportunity. Let me start by talking very briefly about international investment law, because I presume that many of the participants may not be fully versed or aware with the intricacies and nuances of international investment law. So I'll spend a few minutes talking about the discipline, and then I'll come to the interface with intellectual property and what has been India's response or how India's practice has evolved in this area. So international investment law is a branch of international law, which has evolved primarily through what are known as bilateral investment treaties. So bilateral investment treaties are the most important source of international investment law. The first modern day investment treaty was signed in 1959 between West Germany and Pakistan. And since 1959 till date, we have about close to 2,600, 2,700 odd investment treaties. This number was actually higher. This number was close to 3,000 a few years back, but quite a few treaties have been terminated by countries, and therefore now the number has come down to about 2,600 odd investment treaties. If we look at the growth of investment treaties, it's very interesting for us to note that from the year 1959, when the first investment treaty was signed, till about late 1980s, we only had 400 odd investment treaties that were signed. Most of these treaties were between developed and developing countries. It's very obvious that the most important motivation to sign these investment treaties was because developed countries wanted to provide protection to their investors under international law who had invested in these developing countries, many of them which were their erstwhile colonies. But from late 1980s, we suddenly saw a proliferation of investment treaties. So if you look at the UNCTAD statistic, it would tell you that from 1989 till 1999, the 10-year period, which coincided with the end of the Cold War in favor of the US against a communist USSR, and the spread of neoliberalism, the investment treaties quintupled. So the number of investment treaties increased from 385 to close to 2,000. And this was the spectacular phase of investment treaties mushrooming all over the world. And a large number of developing countries also started to sign investment treaties. And as Professor Benjamin mentioned in his introductory remarks, In case of India, the year 1991 was a watershed year in terms of India's economy. And it was in 1991 when India decided to give up on the old quote unquote socialist model or the socialist model with Indian characteristics and fully embraced market economy, opened up its doors for foreign direct investment, so on and so forth. And it was only natural for India then to sign bilateral investment treaties, with the first investment treaty being signed, ironically as it may sound, with the UK in 1994. And from 1994 till about 2010, India signed close to 80 odd bilateral investment treaties. I'll return to the India part in a bit, but let me just finish the international investment law. Why is it important and what does it mean? So, what do investment treaties do? Investment treaties basically provide protection on a reciprocal basis to foreign investors. So, if an investor from country A has invested in country B, the host state of country B and the host state of country A are both under obligations to protect investments which the other investor has made in their territory. Now, what are these obligations? Well, most of these obligations are negative in nature. So the states are required not to discriminate, not to expropriate unless or until there are reasons of public interest, etc., to treat foreign investors fairly and equitably, so on and so forth. Now, what has happened, especially from the late 1990s, is that the number of disputes between investors and states have increased like anything. So, investment treaties have this very unique provision, which you would generally not find in public international law, maybe barring some human rights treaties, where an individual in his individual capacity can actually bring a claim against a sovereign state for their sovereign action. So let's assume if India or Indian Parliament has enacted a law which a foreign investor believes infringes its rights, the foreign investor directly, without the permission of the home state, can bring a claim against India, challenging that law and saying that it violates the respective investment treaty. So this investor state dispute settlement, which in literature is popularly known as ISDS, is what gives investment treaties or what makes investment treaties really what they are. And that's why we are discussing them. So if you look at the number of ISDS disputes since early 1990s till date, according to UNCTAD statistic, there are more than 1,300 such disputes which have been brought. Now, to put this number in perspective, just compare this with other international law dispute settlement mechanisms that we have. A good comparison can be the WTO dispute settlement mechanism. And if you look at the WTO dispute settlement mechanism, which now is in crisis, has seen about 600 odd requests for consultations to be made. Now, of course, consultations doesn't mean that it would definitely become a dispute, but we can say that there have been 600 odd instances of disputes between WTO members within a period of almost 3 decades. If you look at the ICJ, the number is barely 200 disputes in more than 70, 75 years of its existence. Again, if you look at the ITLAws or if you look at other international dispute settlement mechanisms, you will not find numbers which are anywhere close to what the ISDS mechanism or the international investment law has thrown in the last 3 decades. So 1,300 cases that have been brought against states. Of course, I don't want to suggest that in all these cases there has been a decision. In fact, the UNCTAD statistics tells us that states have won more in comparison to investors. So it's not that investors have prevailed in all the situations and all the claims that they have brought, but the fact that so many disputes have been brought against the states have agitated a large number of states, including India, which then took the decision of drastically cutting down its investment treaties or trying to firewall its sovereign regulatory measures from ISDS claims. And this is where the aspect of intellectual property becomes important. So, what is the entry point of intellectual property when it comes to investment treaties? The entry point is the definition of investment. So, if you look at any typical bilateral investment treaty, it contains a definition of investment. And the definition of investment in most bilateral investment treaties follows what is known as a broad asset-based definition of investment. And in this asset-based definition of investment, you have intellectual property rights as well, which means, hypothetically speaking, that if a state were to enact any regulatory measure which infringes or which allegedly infringes the intellectual property right of an investor, there could be a potential ISDS claim. And this is what brings the interface between investment law and intellectual property rights. Now, just to develop a little more on this hypothetical example, and something which many scholars have written over the years, right from Carlos Correa to Brian Mercurio, I have also written on this, is that what happens in a situation, and this is a factual situation which I would like all of you to consider, what happens in a situation where a country issues a compulsory license on a patent held by a foreign pharmaceutical company, and then the foreign pharmaceutical company brings a claim against the state, an ISDS claim against the state, alleging that this issuance of compulsory license amounts to expropriation of my investment. Now, will this be a case of expropriation? Well, there cannot be any easy or straight answers that can be given. But what is important for us to understand is that the ISDS tribunal will surely have jurisdiction. Why? Because intellectual property rights are recognized as part of definition of investment. So if you issue a compulsory license on a patent held by a foreign pharmaceutical firm, there can be a potential ISDS claim. Now, whether this ISDS claim would result into expropriation, that would depend on a number of factors. Most importantly, it would depend on the language of the investment treaty. Now, this is where we can draw a distinction between older investment treaties and the new generation investment treaties. So, if we take India's, and now I talk about India's treaty practice on this point, if we look at all the Indian investment treaties that were signed from 1994 till 2010, and this was part of my PhD work and hence has been part of most of my research work, we find that almost all of them contain intellectual property rights as part of definition of investment, but none of them exclude regulatory measures pertaining to intellectual property right from the ambit of these substantive provisions. So if you look at the expropriation provision, for example, in the older investment treaties signed by India, they do not create an exception for issuance of compulsory licenses, for example. This started to happen only in late 2000s. In fact, US model BIT and the Canadian model BITs were the first ones to exclude issuance of compulsory license from the purview of expropriation. India, for the first time, introduced this in some of its investment treaties and also in its FTA investment chapters with Singapore, Korea, Malaysia, and Japan, where it started to exclude issuance of compulsory license from the purview of expropriation. Now, many critics would say that why should this be done? Because there is no surety that simply because a state has issued a compulsory license, it would definitely amount to expropriation. As I said, it would depend on a large number of factors. But the fact that there is a gap in the treaty language can actually help the investor make the claim on that front. And therefore, the states realize that even if on merits the investor loses, there is still a possibility of the investor bringing such claims, and thus it would be good to plug that gap by redrafting the treaty language and excluding issuance of compulsory licenses from the expropriation provision. So if you look at the new generation investment treaties, you will find that not just India, but many countries have started to exclude compulsory licensing from the purview of expropriation. Now, if you look at the model BIT that India adopted in 2015, and I was part of the Law Commission of India, which drafted its report on the draft model BIT. We interestingly find that in the Indian BIT practice, India has actually gone a step ahead. So if you look at India's model BIT, the final version that was adopted in late 2015, early 2016, and the subsequent bits that India has signed with countries like Belarus, Kyrgyzstan, Taiwan, even with the UAE recently, you will find that India now not only excludes the issuance of compulsory licenses from the purview of expropriation, but it also excludes the issuance of compulsory license from the scope of the entire treaty. So what does it mean? It basically means that if India issues a compulsory license, it cannot be challenged as a violation by the investor of any provision of the investment treaty. Now, this is something which we need to understand, because if you exclude issuance of compulsory licenses only from the purview of expropriation, it means that the investor can still challenge the issuance of those licenses as violation of other substantive provisions, such as fair and equitable treatment, right? But if you exclude issuance of compulsory license from the purview of the entire treaty, then the investor cannot bring or at least will struggle to bring a claim, an ISDS claim saying that the issuance of compulsory license violates any of the substantive provisions of the investment treaty. So India has gone a step ahead in comparison to the treaty practice that we generally find and which is now well accepted amongst a large number of countries. Now, there is another important aspect to this, which is that if you look at the final model BIT that India adopted, it has this language which says that issuance of compulsory licenses will be outside the purview of the treaty, provided the issuance of compulsory license is consistent with the WTO agreement. Now, this is a language which you will find generally in several other investment treaties as well, not just by India, but by other countries as well, that the issuance of compulsory license will be outside the purview of the expropriation provision if the issuance is consistent with the WTO agreement. Now, the question that arises is this: who will get to decide whether the issuance of compulsory license is consistent with the WTO agreement? So let us assume a situation where an investor wants to challenge this before an ISDS tribunal. And the state says that no, this is a compulsory license which has been issued in accordance with the TRIPS agreement. Then the ISDS tribunal will have the jurisdiction to decide whether the issuance of the compulsory license is consistent with the WTO or the TRIPS agreement or not. And this is a function typically which one would expect a WTO panel to decide, right? So this gives the jurisdiction to the ISDS tribunal to decide a question which is primarily a WTO law question. And it is quite possible that the tribunal might come to the conclusion that the issuance of ISDS is consistent with the WTO, and therefore the claim doesn't arise. But what if the tribunal were to come to the conclusion that the issuance of compulsory license is not consistent with the WTO? And if it is not consistent with the TRIPS agreement, then it means that the ISDS tribunal still has the jurisdiction to answer the larger question whether the issuance of compulsory license has violated any of the substantive provisions of the investment treaty. So this is a tricky matter which still remains unresolved. And since my time is now coming to end, I want to raise another important issue. So far, I have spoken only from the point of view of the state and the state's regulatory power. But there's another side to it. As scholars, as researchers, we are trained to look at both sides and all sides of the argument, right? So that we reach at the right conclusion, or as right conclusion as possible. The other side of the argument is that, and this is where the critics of the India's treaty practice become important. They say that by excluding the issuance of compulsory license from the purview of the entire treaty, are you not tilting the scale in favor of the state against the investor? Because what if the issuance of compulsory license was done not following the principles of natural justice, for example, or was done without following due process, so on and so forth? Now, as any student of international investment law would tell you, these are elements of the fair and equitable treatment provision in bilateral investment treaties. So it is possible that the issuance of compulsory license does not amount to expropriating the foreign investor's investment, but it would still be a case, or it could still be a case of violation of fair and equitable treatment. So by completely eliminating or excluding such IP-related regulatory measures from the purview of the investment treaty, are you not tilting the scale in favor of the host state, which it could abuse to its own advantage to the detriment of the foreign investor? This is a valid question, in my opinion, and it should be tackled with. And therefore, in my opinion, the correct or the more appropriate drafting would be that you exclude issuance of compulsory licenses from the purview of expropriation, something that India has done in its previous investment treaties, rather than excluding it entirely from the investment treaty as a whole. Let me end by saying that if we look at India's evolving investment treaty practice, we find that India is not signing investment treaties today at the same pace at which it was doing in the 1990s and 2000s. And there are several reasons for this. The most important reason is that the high number of ISDS claims that India has faced in the last few years has resulted into a rethink in New Delhi on whether we should be signing these investment treaties. There's another very important aspect that whether these investment treaties actually result into foreign direct investment inflows. Because one argument is that India is the highest receiver, one of the highest receivers of FDI. So if India is receiving FDI even without investment treaties, then why does it need to sign these investment treaties? So these are the arguments which we generally hear in favor of the current approach, which is to sign investment treaties slowly and gradually, only on our terms, which will help India to safeguard its regulatory power. But on the other side, there are equally compelling arguments, which are that given the sort of high cost of doing business, perhaps an investment treaty gives that extra comfort to the foreign investor, which they need while they operate in foreign land. So from that standpoint, an investment treaty is still important. But how do we ensure that frivolous claims are not brought by investors against the state? Well, you can never ensure that any litigant will not bring a frivolous claim. Whenever you accept any legal system, you have to accept the risk that there would be frivolous claims, there would be claims which lack merit. But you have to continue with the legal system. You can't say that we'll close the legal system because there are frivolous claims, right? The thing that the state has to keep in mind is that as long as it acts in a manner which is non-arbitrary, which follows due process, even if claims are brought against the state, those claims will not succeed, right? So therefore, if India, and coming back to the IP aspect of it, if India were to issue a compulsory license which follows the requirements which are given in the Indian Patent Act, and I'm sure India would do that. There have been very few instances where India has issued a compulsory license. But if India were to do that, it is, and even if an investor were to bring a claim on this, saying that it violates its investment treaty obligations, it is highly unlikely, in my opinion, that the investor would succeed, right? Because our Patent Act fully incorporates the WTO standards. It is fully compatible with our WTO obligations. And if we act in accordance with our Patent Act, it is highly unlikely that any ISDS claim against India on the issuance of compulsory licenses would succeed, right? So therefore, I think it's important for India to safeguard its regulatory power, which it has done, but at the same time, it should do it in a manner which sends out a positive signal to the foreign investor that there is something for you also in the game, and the scale is not fully tilted towards protecting the host state's regulatory power. So I'll end with this because I know there are quite a few speakers and everyone should have adequate time to reflect on this topic. I once again thank University of Mysore for this opportunity, and I wish this conference, this webinar, a great success. Thank you very much.
Thank you, sir. Thank you so much for your excellent speech.
Recording stopped.
Professor Nicolas called that he will join us now, not 6:30. Yeah, that's what I went out. Okay.
Please, you can join. So I will leave.
Okay.
Yeah.
You can go on.